My goal is not to provide like a clinic for all of your problems, but to give you some ideas how to interface with lawyers and your clients and make the exercise useful. But since the practice of family law covers a huge spectrum, today I'm supposed to talk to you about common law spouses, because there are developments which directly relate to what I have accomplished in getting us to this point. And I'm not sure I'm entirely proud of the results that have flowed from that, because I think it has actually made it harder in some ways, certainly made it more expensive for common law spouses to solve their difficulties. So I think one of the useful things for me to do, since I do have this much time, and I think there's supposed to be a Q&A at the end of it. It'll be whatever duration is left subtracted from 90 minutes, so we'll see how it goes. But I don't tend to belabor the discussion or get into all the little fine points about legal issues, because Marta has done an excellent job. You have a takeaway that is extremely valuable. She writes regularly for the Lawyers Weekly, and you have something that you can take, stick in your filing cabinet, read, and it'll give you an up-to-date analysis of exactly where we are today. It doesn't answer all the questions, because all the questions aren't answered yet. We don't answer the questions, we just make them up. Now, so I'm going to give you, to help you understand where we are now, you need to know where we were. I won't belabor that, but it is helpful to understand that, and I've pitched this at a level of knowledgeable professionals, because sometimes in my other work as in estate work, I get to address a lot of people who, in lunch and learns and stuff, where we come down and talk about how to get more money out of the government and stuff like that, that are of interest to them, or how to keep their children from stealing all their money. Those are other interests of particular close to my heart. Elder abuse is my niche practice. And so, anyway, let's get on with it. When I started to practice law in 1974, the law of constructive trust was really in its infancy. My ultimate appearance in this case was the last evolutionary step in the growth of this legal doctrine, which is really an equitable doctrine. And the case is called, when you look it up, Kerr and Barrow. You'll see it in the notes. You won't be able to find anything I'm saying directly in the notes, so don't exercise yourself trying to say, where is he? I'll let you know at the end. So the point here is that the case was called Kerr and Barrow. Now, those are the BC guys that signed up first. They had a specific issue. I actually went out to Vancouver to meet with them before it was heard and find out what they were doing, so we wouldn't be crossing swords. But they had a fairly narrow issue for the court, and they were gratified that I was going to tag on to them. But it was fun. I was visiting my mother-in-law, so it gave me something to do. Well, my mother-in-law was visited by a party of the third part. So it was good all around, actually. But this case came up. The controversy started way back in 1975. I just finished law school, and the first case that came up was called the Murdoch case. And Irene Murdoch was a farm wife. And they were married, but the ranch was registered in the name of the husband. And Mrs. Murdoch made a claim based on her efforts as a farm wife, which, as everybody knows, is just as hard work as doing the actual work in the fields. But the claim was dismissed ultimately because it was held that she was just doing the stuff that a normal farm wife does, and she didn't deserve any extra compensation. Well, you can appreciate that coming from an old judge in the Supreme Court of Canada was not popular. And it was right in the heartland of the feminist movement at that point in time. So then there were other cases which are starting to come forward, which are funded by various feminist groups for equality. And Mrs. Murdoch should take her place in our history as the forerunner of all of this stuff. In that case, you may recall that we had a judge named Laskin, and he opened the door. He was the dissenting judge. And he opened the door to the whole idea of a concept of constructive trust founded on the unjust enrichment of one spouse at the expense of the other. After that came Mrs. Rathwell, and there's a whole bunch of ladies coming to the Supreme Court of Canada now with their different take on what Mrs. Murdoch had already started and opened the door with Laskin's dissent. Mrs. Rathwell had, also a married person, had made a financial contribution to the farm, which of course was still in her husband's name. And the court picked up on Laskin's dissent and said, look, it's time to change this. This is not right. And the other judge had departed, Martland. He was a crusty old bugger. I remember appearing in front of him, and he was truly a guy who just seemed devoid of an instinct that how these things should happen. It was just cut and dried. You didn't own it, that's what you get. And nothing is exactly the answer. So in this particular case, some of the newer judges on the court came along with Laskin, and the law started to evolve. They were still struggling with the concepts, and they had different reasons for doing the right thing, but ultimately they did the right thing and awarded Mrs. Rathwell part of an interest in her husband's farm. Not 50%, but part of an interest in her husband's farm because of the efforts she had made. It just made sense. Why should title make any difference in how things are shared after a lifetime, and these are long lifetimes on the farm. Then came in 1980 a case in Hawkesbury, Ontario. It was an apiary, and there were two people, Lothar Petkus and Rosa Becker. They weren't married. They lived together between 1955 and 1974 and ran a beekeeping operation. And Rosa Becker, when they split up, Lothar Petkus was a mean man, a really mean man. But Rosa Becker was the heart and soul of the bee operation. And this time, the court found 6-3 in favor of Rosa Becker, and she was allotted a piece of the beekeeping operation. Sadly, Lothar Petkus burned this whole operation down rather than see her have any of it, and she committed suicide. So the story has no happy ending. We should be grateful to Rosa Becker for having stood up to this man and to have presented her case in the Supreme Court of Canada to give us another step forward in the quest for sharing and equal rights between people who are not married to each other. In the opinion of the judge who decided the case, he said there were three basic elements. The first is a finding of unjust enrichment. There's an imbalance to be addressed. Secondly, there's a corresponding deprivation, because one guy's got all the assets, the other one is now deprived of them, even though she had made her contribution to it. And thirdly, there's no legal reason why this should exist, really. So, where one spouse prejudices herself or himself to the benefit of the other, the court now will intervene in an equitable way, which is, that stuff goes back to the Magna Carta, the courts of equity, and what they were trying to do was mollify or lessen the hard effect of the written law or the common law as it was. These were courts that tried to figure out a way to create legal doctrines that would ameliorate hard law situations. So we worked from Peckus and Becker. The first sign that the contribution of one of the spouses didn't have to be a monetary one. Rosa Becker never got her hands on any of the money in the B operation because Lothar took it all. But she worked every day. So the court weighed her labor. And so it opened the door then to someone who doesn't actually have the financial resources coming forward and participating in the fruits of her labors. And the extent of the interest is proportional to the contribution. Not everybody makes a contribution in that way. There will and have been other cases where, for instance, the farmer worked the farm and the wife went off and taught school. So her contribution would have been, and not a wife but a common law spouse, her contribution would have been just contributing her salary. So it's different as to whether or not she should get an interest in the farm he had always owned and inherited from his father. I know that when I have had cases of this nature, even now, appearing in front of judges, local courts, I get the sort of music from the judges that they, look, I'm not going to break up a farm. I'm not going to put this farm out of business. It's been here for 150 years. We're going to give your lady some money, and that's all we're going to do. And so then it just becomes a question of how much. And as long as the how much is satisfactory to my lady clients, then that's cool. She didn't want to farm anyway. She didn't even like farming. She didn't like her father-in-law either. In 1986, the Sorokin case came to the Supreme Court of Canada. It was Mrs. Sorokin showed up, and she had been cohabiting with Mr. for 42 years. You think not only would you get an interest in the farm, but you'd get a medal. Mr. Sorokin owned that farm before he was even in a relationship with her. They had 6 children, and she did more than her share of the farm work. So this was a real farm wife. And so the case extended all of her household chores, her child-raising efforts, all of the stuff normally fall to women on farms, to amount to a 50% interest in the farm. They had been there for 42 years. They couldn't have done it without each other. And so that's where the Supreme Court finally starts, when the lights come on, and they say, now we're starting to do justice. But the case that followed it, called Peter and Beblow, this is one in which Madam Justice McLaughlin brought her wisdom from the province of British Columbia to deal with the case where this lady raised Mr. Bedwell's 2 children, her 4 children. They lived in his house. She did all the housework, all the cooking, all the housekeeping, everything. And she had a job. And Mr. Bedlow, he just went to work. He was a traveling salesman. He was unfaithful. And you won't find it in the reports, but he was also a wife-beating alcoholic. So he was not going to be a real candidate for the exercise of equity at the trial level anyway. And so, but the problem is you have to work within the law, and it hadn't really evolved to the point where someone in Mrs. Peters' situation could benefit, because at least one court held that she'd had free rent all those years. Yeah, try to swallow that one. Okay? So I think she had some backing to get to the Supreme Court of Canada. So what the trial judge had done is just valued her services. He said she's good for $350 a month as a housekeeper, so we'll just calculate the value of those services over 12 years and see how that works. And he gave her $25,000. So That didn't sit well, so they went ultimately to the Supreme Court of Canada. And Madam Justice McLaughlin sorted it out and said, look, I know she didn't actually build the house, I know she didn't actually own the house, but he couldn't have kept the house if she hadn't looked after all of his kids and did all the housekeeping, painting, fixing. She did everything. And the bum is not even supporting her now. So here's what we're going to do. We're going to figure out a number that's roughly equivalent to the value of the house, and we're just going to give it to her. And so they just said, he has no money, he drinks it all, so let's give her the house, at least everybody will be safe. And she even kept on looking after his kids. So there are still some saints out there saving the lives of women in Canada, making things equal. And it advanced the law because it adopted the view that household chores could be used to be valued. And the real problem is, what value do you place on them? And I think they stretched the law in that case because she didn't make a direct contribution to property, which is what's normally required. Like if your husband owns an apartment building, you do all the janitorial, and you're contributing money to help him pay the mortgage and accrue the value in the apartment, well, then you should share in that, right? So it weighed the value of a contribution that didn't come out of her purse. The only trouble with that is men started waking up to these prospects, and we then had the arrival of the metrosexual man who does housekeeping. You know, the kind of housekeeping we're talking about, eh? I do the dishes, therefore I do all the housekeeping kind of guy. Or I cut the grass, and therefore I deserve the same rewards as my wife, who's done 90% of everything else. But you get these guys coming forward to court, and they feel that they have balanced the scales a little bit, and that the whole reward shouldn't go to a common law spouse who's provided just about everything else. And it's interesting to watch them describe their meager efforts in court. I remember one guy said, I load the dishwasher every night, and sometimes I take the laundry out of the dryer, and I said, you put it away? He says, I don't know where it goes.
Oh, yeah.
I'm sure you're familiar with these people. I don't know where the laundry goes either, but I do put it away. So we, in the case that I took before the court, Mrs. Van Ness, she'd been working for CSIS. He was working in a government job. But, so that made them equal. You know, they're both contributing, and they produced 2 children, and then he basically figured out something that somebody outside the government would need from all of his work in the government, and he decided to leave the government to go off and develop this thing. Well, Terry bought it for $11 million. And even though this couple was happy as clams, they were going to get married, there was even a ring purchased, as soon as he got his $11 million, that idea was less appealing to Mr. Sagan. And so he said, well, no, I'm not going to marry you. And then the wheels fell off after that, because she realized what a selfish person he was. Because she had, in the course of doing all those things, quit her job, had the kids, looked after the kids, moved to Nova Scotia, where he was now working, and allowed him, by her efforts, to go off and develop his thing 24/7 until it was done. And that's exactly what happened at the trial. The court held that she had made a contribution without which he never would have succeeded, because he wouldn't have been able to get out of the house. But there was no direct connection then. You see, she was just looking after that stuff. And there's no direct connection with his development of the thing except kind of a but-for test. And that's not something the court had been facing with, in the Supreme Court anyway. What the judge did, it didn't divide it equally at the trial. She took a 12-year period of cohabitation, the first period was when they were both working. No deprivation there, no unjust enrichment. So that's the first third of their relationship. The second third is when she really did suffer a deprivation and provide something. And then he got his money. Well, he didn't need to work anymore. Would you work if you had $11 million in your bank account? No, you would not. And so he didn't. But he thought, I'm at home now, I can do chores. And he's the dude that lifted the stuff out of the dryer and thought he was Mr. Metro Man, and the judge didn't buy that stuff. But she said there wasn't any real deprivation because he was around to look after the kids now, and he stayed. She would rather he hadn't stayed home, as you might find later on in life with your husbands. They get underfoot looking for something to do, but that's another story, isn't it? Anyway, we were successful at trial in getting her $1 million in cash, had the other half of the house, and got to keep the RSP he'd set up for her. He got to keep, after tax, about 3 times that, roughly. So it wasn't an equal division, but at least it was something, and it was a big one. This was the biggest one that had ever happened in Canada. And it made it rather unique in that way, because most times people can't afford to litigate. And anyway, Mr. Sagan was beside himself with grief. So he hired his lawyer to go to the Court of Appeal. And the Court of Appeal was they had a number of decisions that were getting kind of backward and retrograde, and they were not evolving the way the courts had in British Columbia, where all this good law came from and where Madam Justice McLaughlin came from. And so there became a dichotomy in the way common law spouses were treated across the country. So that's the door opener when you get to the Supreme Court of Canada. But the Court of Appeal took what, fortuitously or not, was the worst possible position they could possibly take. They sent it back for trial. She said, "You're not paying attention, Mr. Johnson. We've already decided these things." And I said, "But wrongly." They didn't take kindly to that either. But they decided to send it back for trial so that her services could be valued on a dollar basis. Just what did she contribute? What was the value of her looking after his kids? And the best we could do was maybe, like in the world, the most expensive housekeeper in Canada, maybe $100,000 a year. And she got $1.2 million. So we were not ever going to produce any evidence for the court to chew on that would allow this amount, to have that kind of amount in front of the court. Luckily, we got a very forward-thinking judge at trial, but the Court of Appeal just sent it back. They granted Mr. Sagan's appeal, and he started doing nana and a boo-boo with his spouse, and that really annoyed her. And because he had all the money to blow on this stuff, we really had to take it on spec because she didn't have any of that money yet, right? So she said, "Mr. Johnson, you have to do something about this. This isn't right." And I said, "No, it's not right." So I said, "Just let me run with it to the Supreme Court of Canada. If we get leave to appeal, we're in." So I did. And the presentation was basically how can a Court of Appeal for a province like Ontario still think like this in the face of several provinces who don't think like this? They started having modern thoughts in BC and other places. Manitoba, Nova Scotia, not Quebec, but that's another story. I'm not doing the Lola case today. But so the court said we have to have uniformity across the country. So they did, and they finally they listened to with great interest. And I told Justice McLaughlin about all the havoc that their decisions had wreaked in the past and all the struggles it takes to get there, and all they have to show for it is someone handing your chit at the end of your relationship and get your money back, basically. And that's it. And that didn't sit well with them. So I thought she would write the decision, but she did not. She let it go with Justice Cromwell, who was a brilliant academic, wrote 80 pages. It makes interesting reading, but it's a little thick, so I'm trying to break it down for you today so you understand where it goes and from here. It was unanimous. They did discard the whole idea that it's simply a matter of handing in your invoice. It's what you bring to the relationship, how you're allowed to share in the overall growth of the assets that the parties accumulate together. So the unjust enrichment fit right in there. It's a disproportionate share of assets arising from a new concept called a joint family venture. And this is key to your studies today or whenever you run into people of this. I'll explain it in more detail, of course. There are 4 factors that are relevant to the creation of this joint family venture. If you don't have a joint family venture, you're not going to succeed in recovering property. And the first, because the court doesn't presume entitlement just because people live together. I mean, I'm sure you have faced or have friends who have faced, I don't want to marry the guy, I just want to live with him. He's not getting any of my money. We separate everything we have. I pay this bill, I pay that bill, I look after my kids, he looks after his kids. So where's the family integration in that? Well, as it turns out, that's one of the factors you have to show in your consideration of whether a joint family venture exists. There's no presumption of joint ownership of any kind. And so the second thing you look at is mutual effort. Have the parties dedicated themselves in common by pooling their efforts and resources, including the raising of their children and assumption of domestic duties within the house? Have they actually all pitched in? Is there a mutual effort? So the second heading after the joint effort is economic integration. You have to show some form of merging of the family venture. I don't think that just means joint accounts, although obviously it helps. And as you know, in family law, it doesn't really matter who owns the assets. When we get to the end of the story, I'll tell you how BC has now dealt with it as a result of the Curran-Baranow decision, because they turned everything upside down on its head. It may have made it a lot easier for folks to get justice. The third criterion is actual intent. Is this what the parties intended? Did they intend to be a merged group? Did they intend to be a unit? Or did they intend to be separate? A lot will be taken from how they act. Not what they should have done, but what they do or did do in their relationship. You have to examine all of the things that went on in their relationship and how they divided up their labor. And the fourth one, had they given over their efforts to the priority of the family, or were they just in there digging for themselves? Were they just a couple each own a Porsche, they each go to their fancy job every day, they each bought a half interest in a house maybe together, and they bought some furniture? Is that a joint family venture, or are they just having a good time? So it's you have to lift the covers and see what happened during that relationship. And you have to find out what their actual intent was. Some people are very clear. They come to you and they say, I need an agreement. I don't want to share anything with this guy. And he doesn't want to share anything with me. You do the drafting, Mr. Johnson. And of course I have to let one of them get independent legal advice to see that they both share the view really. And one guy's not dragging the other one in to browbeat a deal out of her. Oddly enough, it usually comes up in two circumstances, which you will recognize, I'm sure, from your own business. There's a disparity in the size of the money pile as they enter the relationship that has to be protected. Quite often it's a money pile that came from on high by way of inheritance, and there's influences from the family that want to protect the money. So if someone wants to marry a Molson, you will get a lot of attention from the Molson family about what happens if, and you don't enter into an agreement whereby you take some sum of money just to go away in the event the relationship doesn't work out. So if you start with a disproportionate share of the wealth, it doesn't mean you get to divide it simply because you live together a long time. There has to be this element of the joint family venture. Whether the reward is money or whether it's a piece of the property will depend on what's available. Normally money is the best remedy. I always say cash is king. Why would you want to own property with that guy? So you already hate him. So we look for cash, and that seems to let him go and mortgage it or find it or whatever you have to do. But there's no reason why this sharing shouldn't take place. You have to ask yourself as you're talking to your clients, why is it, like what has to happen here to make this work? And is this really going to be a successful claim? A certain irony in this. Cromwell J. did such a great job outlining all the steps that you have to follow to make a joint venture. He actually prepared a list of which if you made a second list negating every one of those things and not doing any of those things throughout the relationship, you could probably avoid a joint family venture. And I think from what I hear from Martha that there are people out there practicing just that. They just know what happens. They don't want to share. They have an agreement, but they're protecting themselves. I don't know what, I mean, it's not my business to be a social worker, but I don't know how that can really help the relationships of people, the not sharing part, the I never want to share part. I mean, are they ever going to be happy, or is this just a banking relationship? People are funny. 40 years of doing this has taught me there's absolutely nothing new under the sun in that regard. So the court has to, as a matter of policy, look at what took place during the marriage, not what should have taken place. And they will reallocate the resources of the couple. If they find a joint family venture, you're in like Flint. But here's where you guys come in to a large extent in the gathering of the information to support this. It's a tedious, lengthy, expensive process to take care of it in that way, because you have to go back and look at everything. Compare that to the Family Law Act, where one spouse can get a half interest in assets accrued during marriage and sit at home eating bonbons. I mean, it's just there. It's given. And it's a recognition of their joint relationship and the choices they've made. They've opted into the system. They get the system. That's what the court was telling us. So you have to, I think, recognize how much greater effort is involved in getting these people what they need from the relationship in a financial way. And it's tedious because it looks under the covers of how they did business on a daily basis. I thought it might be interesting. We should have a look at some of the cases that have followed this case, because it's now 2 years old. I mean, I should tell you that. I gotta watch my time. I should tell you a little story on myself. I was been living with this woman for about 10 years, and this case was coming to hearing in the Supreme Court of Canada, and we were supposed to go away to Antigua, but the case was coming down on the day that we were scheduled to go away. And my wife said, well, you know, we're going with people. I was on their honeymoon. It'd be kind of fun if they went on our honeymoon. So I said, are you asking me to marry you? She said, yes. And I said, well, you better get your act together. We're leaving on Friday. And so she went and got all the licenses and everything, arranged for a minister in the house. And, oh, that's cool. I never really pushed the issue with her because she's a nice person and we didn't have any difficulties, so I messed with that. But I'm a big fan of marriage. So we agreed that we would get married on Friday. And on Friday, of course, this landmark decision comes down supporting common law rights all across, but I'd already committed to the marriage part. So when the CBC called that day, they said, we want to come and interview. I said, I'm sorry, I'm getting married this afternoon. And I said, you print that, I'll come and I'll kill you. So, but I'm telling you guys, it's just something that we did, and then we went. Those other folks came along on our honeymoon, so it was a lot of fun. And I'm still married. 2 years ago now, February 18th, 2011. I know that date because I know when the decision came down. My wife doesn't know that date. She never knows that date. Yeah, landmark decision. Not so much a landmark for her. I guess. I don't know. We don't exchange presents, so it's not recognized in any way. We just go on a trip. I'm just making sure that I don't become...
Can I ask you what the ruling was at the Supreme Court? Because I'm just not seeing anything.
Well, they restored the trial judge's order. They gave her back her $1 million,
Yay.
the other half of the house, and the RSP, and awarded her, in addition to that, $250,000 in legal costs, which you won't find. Oh, yeah. I mean, I had been running this tab for ages, so I was out there too. And I certainly put a lot of effort into winning. And it was just time. And I would not have really shed any tears for losing the money. I would have shed a few tears for losing the case, because she became a very good friend. I got to know all of the members of her family. I went to her father's funeral, and we had a celebration party after, and she gave this wonderful dedication. So there were a whole bunch of other rewards besides financial, but I've got to keep my partners happy, so we got that money out of Mr. Sagan, and that brought great joy.
And how did he react to that?
How did he?
Was he as joyful?
You want to know? He was just hopping, and he was hard to control for months. He would just be so surly, and we would, every time it was time to pay some more money, we'd track him down and force him to cough it up. But he was very difficult after that. But then he had so much more money, and he was doing the right things with it. Eventually he settled down, and they seem to get along now. You know, the kids are now teenagers. They go back and forth. Daddy actually does the chores now in his house, though, or his yacht. And the kids are happy to go back and forth. And they both remarried happily.
So the money made him a jerk.
Woohoo!
Yeah.
He saved himself a lot by just acknowledging that at the first level. But we went on to change the law. Good on us. Okay, so some cases, let me give you some examples of how these things go down. The first one I want to talk about is called Rubin and Gendeman. This was an Alberta case in the Court of Appeal. There was an 8-year relationship where the parties had no joint bank accounts, no joint property, and they'd never identified themselves as spouses on tax returns. So when you go looking around for evidence, I often go to the tax return just to see how they called each other, whether they were even there. And sometimes there's a reason why you wouldn't put your spouse there, but I don't know what it is. So I look for that. They didn't name each other. These two didn't name each other on insurance policies. They didn't name each other on RSPs, which is, as you all know, stupid, because you can get a rollover one way or the other. I mean, whoever goes first loses, right? But they get the RSPs rolled over, and you get to spend it all before Mr. Harper gets all of it. And there was no insurance left to either one, and they didn't name each other in their wills. Why they went to court with this case, I don't know, but they did. And the court held that the applicant largely spent the money on herself that she earned, and this was not a joint venture, and no money for you. It's threw her out. The trouble with these things is you do take a bit of a chance, because if you lose, as you know, you can end up paying costs like Mr. Sagan did. So, but there were no marriage-like characteristics of this relationship. This was almost like a business. I'm not sure why they even got together, but there was just nothing to exemplify the kind of conversation that I see in my office on a daily basis.
Why would they think why would they take it to court in a case like that? Why wouldn't a lawyer step in and say,
well, when I read
this hasn't got a lot of legs?
When I read these cases, I just think they didn't have good representation. So it's bad lawyering. Use your head. I mean, you're not going to win this thing, but sometimes these, as you will experience from time to time, I'm sure, lawyers run cases because their clients demand it. They should not. They really should not. They should be discouraged from just doing that. But some of them have a point of principle to make. Well, all that does is put that principle in my pocket. Okay? You want to run with a stupid case, you're going to lose. I want my money up front because you're going to be really unhappy with the result. And I don't make any bones about it. I don't believe in litigating just for the sheer hell of taking somebody apart on the stand. It's enjoyable, but still.
John, I'm going to suspect in this case there was a large disparity of assets. He owned an oil company. I'm going to that is quite an imbalance.
Yeah, but you don't get the share if you don't make the contribution to the group. He may have had that when he walked in. That may have been the attraction. But that doesn't get you, as a common law spouse, that doesn't give you a share unless you meet the other requirements.
But sometimes what people do is just say, I'm going to give X amount of dollars to make this go away.
Yeah.
We have so much wealth. We're forever happy.
And that actually fosters the litigation. We do lots of what I call hold-ups, where you simply threaten the litigation and the guy says, I got 50,000 to him or 50,000 to her, and I don't have to sit in a courtroom with her, so I'll pay her. And they walk away. But that's not a legal resolution. That's just a fact of life. I can't afford to litigate, or I don't want to litigate. The courts are very unpredictable places. I can't say that with different representation, she might not have succeeded. You know?
What was she looking for? Who was looking for what here?
I don't have all the facts right in this particular case, but I think she was looking for something like 25% of the property. She didn't get anything. They had no joint property. She got what she had and kept it. And that's the same thing. But you have to ask yourself, don't presume that somebody like that deserves a share. She did nothing to contribute to it. Just because she's a she doesn't mean she gets it. The way the Supreme Court of Canada looks at it, you're supposed to get married if you want that kind of benefit. Yeah, not very funny, but...
I have a question with the joint venture. You didn't list children.
Children are part of it because that's part of the integration, the mutual integration of the family. You'll find a much more detailed discussion in the paper that I've given you, and so that you'll be able to sit down with your client. I tried to make sure it gave you a working text that you can use to...
would be part of that.
Yeah.
Because I would think, obviously, they had 6 children, there was a family in Kent.
Right, but maybe both of them looked after the children, you see? So how does that get you a reward, you know? So couples who deliberately contribute money to the relationship for the purpose of acquiring assets and sharing expenses have a much better chance of approving a joint family venture. But this is it's the string savers, foil keepers, and bookkeepers of the world who actually win these cases. Because they write down everything. They've got bank records going back to 1990 about the wonderful things they did in the paint they bought, and they know what color it is. It's written on a chart, so they don't have to go looking for it and matching it at Home Depot. They've got it right there. That kind of people, they win. And they're usually women, because the guys, they're useless. They come in, so what'd you do? Well, you know, I go to work every day, and they're sort of laconic about it. Did you do look after the bank accounts? No. What'd you do? I just hand over the check. Is it a joint account? Sure. I mean, we both have to get money out of the account, you know. What about the furniture? He says, you think I like furniture shopping? So the furniture, all the invoices come out in her name because she picked it. The good thing is he probably doesn't want that furniture at the end anyway, so that doesn't matter. Used furniture is not worth very much money. What I'm getting at here is that it's an attention to detail situation. If you're going to get into that relationship, be a good record keeper or know how to do it. The saving grace is the invention of the computer. Not only does this computer have a lot of couples' financial records, it has mostly a record of all of their conversations with each other on how they share and what they thought about this or that. And so we actually have evidence now that we never had before. It's very fertile. And archives are a wonderful thing, and hard drives, they still produce an awful lot of data, even if it's tried to be stripped. Someone was trying to get rid of records. Don't have your computer emptied or whatever they do to computers. Throw it in the river.
Drive your car over.
Yeah. So the people with the best records have a much better chance of success because they can calculate on a day-to-day basis all of this stuff. And part of your job, and fortunately not my job anymore, is to gather this tedious information and make it into something that's vibrant and shows clearly the path that these people have followed. Not what they should have followed, but what they have followed. So you will be doing a real service for your clients to get into that, as well as doing their financial planning. I understand what your job is, but since you asked me to talk about it today, this is what I think your job could be. It certainly would help us as lawyers to have someone come in with the thing already packaged straight out of the computer. That would be grand. It never happens, but that would be grand. The problem with that kind of accumulation of data is that kind of accumulation of data, if forced to a court, has to be presented there. That is a tedious thing. That's where I come in, and we go through the books. And we just review and review and review, and it takes days. And the judge has to sift through what he said he did versus what she said she did. And they'll both not be telling the complete truth. There always is going to be an exaggeration. And sort of that's where our job is, sifting things out so we can find a truth that works for the judge. And that's how we do it. But that's hellaciously expensive. And it's way more expensive than the married couples have to go through. You know what the Family Law Act looks like, don't you? So you You go to the formula, you figure it out, you got the Form 13s, you know what they tell you. It's all systematized. By the time you get to court, the result is obvious. But with common law couples, they're still thinking about who did actually paint the bedroom. You know, who actually put in the garden? Who did the flagstones? You know, that kind of stuff. It's tedious and it's hard, and it's no bargain for common law spouses, even if they're going to be successful.
So it's really important that we tell our common laws to start documenting everything.
Absolutely, from the day they enter the household.
That's really disgusting.
It is disgusting, but the good news is there is a remedy at the end if you can't settle it.
Yeah.
I am a big believer in settling. The NAS is probably, well, it was the last trial I did. And as much as I like trial work, that's what I do. That's really what I enjoy. It keeps the adrenaline pumping and me alive. And, so I enjoy that. But not everybody, enjoys the process like I do. So here's another case. Couple was 70 and 75. It's the Steele case. They were 40 years together in unwedded bliss. I thought that the joint family venture would have been presumed. You stay together that long, surely to God you've got a joint family venture going for you. They must have shared something along the way. And the court said, why is this case before the courts, you idiot lawyers? This is an obvious case. They put these old people through the ringer, and it's an obvious case where they should have shared everything equally. 42 years. How many, hands up, how many people have been married for 42 years? Wrong, eh? It doesn't happen. So that's what this case illustrates, that why, fortunately we go through mediation a lot now too. That's a good process. Collaborative law, another process that eliminates all the crappy cases and makes people agree by having several people focus on the one who's being reluctant and get the job done. There's some people who are confused, broken hearts with broken wallets, and they want to pay for the pain, to be paid for the perceived pain that's been inflicted on them. I could have got about 6 psychology degrees for all the work I've done over the years. I'm really good at it, but it wears you out day in, day out. And it's very expensive for the people who sit in front of you and you say, you really can't tell me all this stuff. There are professionals out there covered by OHIP. No, but you always tell me the right thing. I know, I'm good at what I do, but this is costing you $400 an hour. I don't care. So I have to temper my own zeal for conversation at that point and guide them to the end of the... I just use lawyers are in the role of using their dependencies. You create a dependency in your client so they'll listen to what you're telling them, but you can use that dependency to push them to the right goal. I know several really good family lawyers in the city of Ottawa who hold the same view I do. Let's have all the facts. Let's sit down in a room together for an hour and we'll tell you how this is going to end together. We'll just tell you how, and you have to accept what we say, and it'd be over. And we'd be real close to the result at the end of it. Because I trust these guys that do the right thing. They can sense what's going down and what's not going down. But we have too many people who are not adequately, I would say, not adequately versed in the law, or too eager to make a living. I'm not sure which to drive these things. And the courts will sort it out eventually. But in the meantime, we have these common law spouses who have to pay the toll to get there. Let me see if I can find another interesting thing about this.
Can I ask a question?
Sure.
I want to clarify that all the things you're talking about common law spouses also applies to same-sex common law.
Oh, absolutely. Yeah, my partner in the office, the head of our family law department, is a lesbian, so I'm the endless stream of gay people in my office. It's exactly the same. They come in, you should have seen what he did to me last night. I've got a bruise under here. What can I do with that? And it's exactly the same. It is the same, and he's no good in bed, and all this stuff that you don't want to hear about anybody. It's exactly the same, and I take it that way when I'm there. When I'm dealing with these people, it's identical. I just say, you two need to get together. You have enough money to make it work. Let's make it work. But there is no difference. Common law and same-sex couples you just treat them as interchangeable. All this law applies to common law and to gay people. Here's an interesting one. There's a new group of people out there called LATs. They don't live together. They just have fun together. They each have a house, which probably comes from the fact that they're widowed. They have their own bank accounts, their own pensions, and they have a relationship. But they're 60 years of age and they don't want to live with anybody anymore. And they have a whole lot more fun just hopping on the cruise ship and having a good time. But there's so much sharing back and forth, and there's a toothbrush in each residence for both, that you wonder if you could ever make the argument for cohabitation. Not the way the law is presently developing, I'd say no. Not in that pure sense. But you can treat those people as ordinary citizens who have given somebody else money. In other words, you can make the constructive trust argument. I gave that guy $50,000 so he could pay off the debt on his car. I don't live with them, but I want the money back. Well, the same constructive trust principles apply to those people. And you should be able to get the money back, but that's all you're really shooting for at that point, is an accounting for the disadvantage you've suffered because he talked you into giving him 50 grand. So, I think there's going to be a remedy for these people. It won't look like the same remedy. We're not going to be examining intent or joint family venture because they don't live together. That would be one indicia, I think, primary indicia of a chosen relationship where people can work together. So, because of the time, I have glossed over what is 42 pages of pure gold that my buddy Marta prepared. I'm going to stop there. I hope I haven't shortchanged you. But you read it. It's fascinating reading. She writes really well. You've got it in your binder.
Oh, it is.
We sing. That's right, eh, John?
Oh, yeah.
Yeah.
Okay. So that's only 9 pages.
You only have 9 pages?
14.
We're not
Oh, I'm sorry. I have to have triple space so I can read the damn thing at arm's length. And I have 14 font everywhere I go. So
Oh, yeah, I'll get no.
that's hell. It's hell. But there's so much to look forward to. Stopping practicing law is just the beginning of another career of doing something. I don't know what it is yet, but I won't stop doing this until I figure that out. So you have your article. It's an excellent article. If you have problems in this area, I commend you to the services of Marta Samarchuk. And we have 1, 2, 3, 4 others now in the family law group. Business is booming, and so we must be doing something right. And this is the only time we ever get to advertise, right? And so the one last note, though, I just remembered looking at Carol Ann, that I had to talk about BC. What BC has done is it read the Kerr and Barronell decision and said, holy cow, that's a lot of work. Now all these people are going to have to fight with each other. It doesn't solve anything, it just gives you the rules of engagement. So we're going to rewrite the legislation and make them all into married spouses, and away we go. So So they have done that now in the new Family Law Act in British Columbia. If you're living together for 2 years, you're a spouse, according to like a married spouse. And it's in Saskatchewan, Manitoba, I think Alberta, and Northwest Territories and Nunavut. So I think Ontario will be the last place. We're so conservative here. But it's time to shuck that stuff off and get on with it. These people need to have the same rights. The Supreme Court of Canada is not going to do it for you. Look at that guy that owned the Cirque du Soleil. They upheld the legislation in the province of Quebec where the lady can't even get support, let alone property, from this guy. That because of the code, and they didn't find that unconstitutional. Holy jeez. I thought that was a terrible decision, just so you know. But I think they had a lot of disagreement amongst themselves too, because they seemed to waffle a bit. But in any event, in BC, the problem has now been solved for you. You have after 2 years. But it's a mechanical thing. If you're not there for 2 years, you're not there. But what the heck, is it a real relationship? If it can't last 2 years? And what about the people who 2 years, 2 years, 2 years, 2 years? Lots of people get together for different reasons. I'm sure you've heard every last one of them. So do you have...
Has there been any testing of that 2 years in BC?
Well, yeah, there was an interesting... Margaret discusses that in her paper. She says, so where does it begin? When does cohabitation begin? So that would be fascinating, but I think it's going to have to begin, given that they've been given what I consider this bonus. I think it's going to have to begin with actually living under the same roof. It's the weekend people that come for what is the Jack Nicholson calls it, Panama City Hump Hump Sailor Saturday night. And you remember that from As Good as It Gets? So there are people who do that. So I think that's going to be the issue. When do they begin? When do they actually start living together? And then that'll open up the door to when the other indicia kick in. But 2 years cohabitation, you're in. You get all the rights of those studs now in British Columbia. There you go. All your work is done. You didn't have to listen to the damn thing I said.
So I do have a question about Columbia, though. Did you follow the actual case at all?
No?
They settled on the court steps.
Mhm.
Apparently she got a chunk of the family trust. The parents were very adamant that they deliberately set everything up this way so that
She wouldn't.
their children's eventual spouses couldn't walk off. But she was married 16 years with 4 children.
The trusts actually are a thorny issue because there is usually a deliberate attempt not to share. And it's usually somebody else's money, not theirs. So where's the contribution? It'll be a problem even in the marriage setting because it's still a problem. We have only got one case where some brave judge in southern Ontario decided to share a trust. It's the Sagal case. And basically what they're looking for is to lift the blankets on the trust and see who's actually driving it, who has access to the money, when, who gets to say when they get the money. Is it completely discretionary? Have they followed a pattern every single year of always handing out checks for $20,000? Is there any real discretion when there's 6 other kids also waiting for exactly the same thing? Or is it just a money pump? All of these things you'd examine in the context of, is it an asset that actually belongs to them? And of course the lawyers are busy bees. They trying to define everything as absolutely discretionary in the hands of the parents, waiting for the next drop to come from the trust. And at Christmas time, each one of them gets 5 large just to go out and have a good time. So, there'll be factual issues too. But that's one you guys can explore with your clients too. Give me a copy of the trust agreement. Show me what has happened to this trust agreement, how the money's been paid out of this trust agreement. And maybe you'll be able to convince some lawyer to take that one on. That would, well, the guy you're going to meet this afternoon, he was a good friend of mine, Steve Pittman. He will give you some insights into the nature of assets and the valuation of assets. Make sure you ask him about trusts, because he is my favorite valuation witness. Did I give you that name, thank you?
I saw him at the State Planning Council.
Oh yeah, okay, another
Yeah.
fertile growing ground for public speakers.
Yeah.
Anyway, Steve's a good speaker too, and has a nice cynical touch to his view of lawyers. Probably you do too. I don't care. So, if you don't have any more questions, why don't you guys, you do?
I have one.
Yeah.
So at this point in time, is the only recourse for common law a couple to go to the Supreme Court in Ontario?
The Superior Court of Justice is the place where you go.
Okay.
It is the only legal place to go, but you have lots of other alternate dispute resolution things like arbitrations,
Yeah.
which will give you a final result which you can convert into a judgment. You knew that, eh? An arbitration award can become a judgment. And but mediations, the trouble with mediation is it can go on forever. If you can't settle a fairly simple case within 2 or 3 days, give up. Get down to the courthouse, have someone bang it out of you. You know, get it over with. Stop chewing the facts to bits and get some judge to decide what's really true and how it's going to be dealt with. We have a very talented bench down there, and they're devoted to the cause. Okay.
This is a Heritage Cookbook, and if you haven't got The Joy of the Next, you might find it.